Hi, I'm attorney Jeff Briggs. Since the devastating Palisades fire, I've been advising and assisting many home and business owners with their losses and their insurance claims, as well as our lawsuit against the LA DWP. While advising my clients, many of the same questions and issues have come up repeatedly. So, as a resource to you, a Palisades home or business owner, I thought it would be helpful to address and break down some of these key issues and answer some of the most frequently asked questions. First, let me introduce myself. I'm Jeff Briggs, and I've been an attorney in California for 32 years. My practice includes complex multi-party litigation, including against public entities such as the LADWP, who we are suing as a result of their deliberate and outrageous conduct, which I will be discussing in detail shortly. My practice also includes insurance coverage, insurance bad faith litigation. Based on my dealings with several insurers on behalf of my clients, we expect a number of bad faith filings over the course of the next several months. Unlike many of the attorneys that are advertising their services to Palisades home and business owners who seem to have moved into the West Side shortly after the fire, my practice has always been based here. I graduated from UCLA and law school here in Los Angeles and have been serving Westside clients for over 3 decades. Before I begin, it's important to note that this information is a general overview only and is not legal advice. The facts and the law vary on a case-by-case basis, and if you have any questions about this information or would like to join our lawsuit against the DWP or would like to discuss your particular insurance claim, please contact me directly, and I would be happy to speak with you as a courtesy and at absolutely no cost. Let's begin with the responsibility and liability of the LADWP and our lawsuit against them. What I'm about to express with respect to DWP are my personal views as well as the allegations in our lawsuit against them. By way of background, DWP is the single largest municipal entity in the United States. It employs more than 11,000 people and has an annual budget in excess of $6 billion. The chief executive and chief engineer, Janice Quinones, is well paid for her decision making and personally brings in $750,000 annually, and we'll get to her decisions shortly. With respect to the DWP and the Palisades fire, the facts that we know for certain are the following. The Palisades sits just below the Santa Monica Mountains and is part of a well-mapped, high-risk fire area well known to DWP. DWP is responsible for servicing and maintaining the water supply system which serves the Palisades. The system that supplies water to the Palisades includes reservoirs, storage tanks, pumps, and water lines, which in turn provide water supply and pressure to the fire hydrants in the Palisades. The largest and most important source of water in the Palisades is the 117 million gallon Santa Ynez Reservoir. The Santa Ynez is a critical component of the overall system which supplies water and water pressure to the Palisades. So, how did DWP's water system perform during the Palisades fire? It failed miserably. Specifically, fire hydrants in the Palisades lost pressure and failed after 3 water tanks, each holding 1 million gallons, all went dry within 12 hours after the fire broke out. The first tank was dry in 6 hours, and all 3 tanks were completely empty by 3 a.m. on January 8th. The fires continued to rage for days with little to no pressure in the fire hydrants for the firefighters to defend Palisades home and businesses. So, what are DWP's excuses for the failure of their water supply system? Let's break down each of them. First, DWP claims that the, quote, system was prepared but overwhelmed by 4 times the normal demand, and that the fire was like, quote, a worst case scenario. The fact is, it is the responsibility and duty of DWP to anticipate, plan, and prepare for all scenarios reasonably likely, including a fire in the mountains and the canyons right above the Palisades, and to ensure that there is sufficient water supply to maintain pressure in the fire hydrants in the case of such a fire. DWP failed this responsibility miserably. Second, DWP claims that the water supply, quote, remained strong to the area. This is completely false. Critical fire hydrants had little to no water pressure when the firefighters needed it most. Third, DWP claims that the water pressure was lost due to, quote, unprecedented and extreme water demand to fight the wildfire without aerial support. As to aerial support, as DWP should know, but apparently doesn't, being able to drop water and Phos-Chek by air is completely dependent on visibility and the winds. Aerial support is never guaranteed, and any reasonable planning and assessment must account for this. Next, of course the water demand was unprecedented. The Palisades had never had a fire of this magnitude before. The fact that something has not happened before does not mean that it is not reasonably foreseeable and should be ignored. For example, if you've never been in a car accident before, does that mean that you should drive recklessly? Of course not. DWP's claim that the demand on the water supply system was, quote, unprecedented and therefore could not have been reasonably anticipated and planned for is ridiculous. Also, was the water demand during the fire, quote, extreme as claimed by DWP? Is 4 times normal demand to fight a fast-moving, wind-driven fire as compared to a normal day of water consumption really extreme? I don't think so. Any sensible and reasonable planning certainly should have accounted for 4 times normal demand compared to a day of bathing, drinking, and other personal consumption. Now, what about the words that you don't hear DWP and its lawyers using? What they don't say is that the higher demand for water during the fire could not have been reasonably anticipated. Why? Because it should have been, and they know it. So, why did the water system fail? This brings us to the San Ynez Reservoir. As I noted before, the water supply system in the Palisades is made up of reservoirs, storage tanks, pumps, and water lines, which, working together, provide water pressure to the fire hydrants in the Palisades. The largest and most important source of water in the Palisades is the 117 million gallon Santa Ynez Reservoir. This reservoir is a critical component of the overall water system. So, how did the San Ynez perform during the fire? The answer is, it did not provide a single drop of water. Why? Because DWP drained the reservoir and left it bone dry for nearly a year during one of the highest risk and most dangerous fire seasons in history. This decision to drain the San Ynez was deliberate and outrageous. So why did DWP do this? Was it because of some unanticipated emergency, a breach, or a leak endangering the life or property below the reservoir? No. Was it due to scheduled maintenance, which due to bad luck just happened to be shortly before the fire broke out? No. Rather, it was drained and left dry due to a small superficial tear in the floating cover that remained unrepaired for 11 months before the fire. The decision to empty the reservoir and leave the cover unrepaired for nearly a year was deliberate and was done knowing that this decision would render one of the most critical components of the Palisades water supply system useless in the event of a fire. What is DWP's excuse for draining and leaving the San Ynez empty for 11 months? They claim it was necessary to meet, quote, safe drinking water regulations due to the potential for, quote, bird droppings and other debris to enter the water supply through the superficial tear in the cover. This excuse is nonsense. The relatively small and superficial tear could and should have been repaired temporarily or permanently by DWP's own personnel in order to ensure the availability of this crucial water during a period of extreme fire risk. According to a manager at DWP's employee union, quote, it's completely unacceptable that the reservoir was empty for almost a year for minor repairs. He explains, quote, this work should have been done in-house and they should not have depended on a contractor to do it. He says, quote, I truly believe it's something that could have been avoided. We could not agree more. LADWP had a duty to properly maintain and operate its water supply system, and it failed miserably in this obligation. So, with this crucial water supply intentionally removed from the system, what was DWP's backup plan to replace the water lost from the San Ynez? They claim, quote, as soon as LADWP identified the risk of losing water in the tanks and water pressure in the system, we immediately deployed potable water tankers to sustain and support firefighting efforts. Let's break down this excuse. First, potable water, which is water safe for human consumption, drinking and brushing your teeth, for example, is not necessary to fight a fire. DWP should know this. Second, let's do the math on exactly how many tanker trucks would have been needed to replace the 117 million gallons lost by draining the San Ynez. A typical water tanker truck holds between 2,000 and 6,000 gallons of water. At 2,000 gallons each, that means DWP would have needed more than 58,000 tanker trucks to replace the water lost by shutting down the San Ynez. Obviously, DWP's backup plan was massively incomplete. Would the San Ynez have made a difference? Finally, I want to address the claims which I've heard from a number of pundits, apparently in support of DWP, that maintaining water pressure in the system would not have made a difference in fighting the fire. This is absurd. Look no further than the areas that maintained water supply and pressure, including numerous businesses in the Palisades, which are still standing today, and compare that to the areas that had no water pressure, which are now in ashes. If you would like to join our lawsuit against DWP, or if you would like more information, please do not hesitate to contact us, and I would be pleased to speak with you directly at absolutely no cost or obligation. Now, if you do want to join our lawsuit, it is very important that you act promptly. Unlike some other types of property damage claims, which may be brought in California for up to 2 years from the date of injury, the timeline is much shorter for a claim against a public entity such as DWP, which must be brought within 6 months from the date of injury or damage, here, January 7th. I want to talk a little bit about the type of lawsuit that we have brought against DWP, which is an independent action rather than a class action. We believe structuring our lawsuit as an independent action presents several important advantages to our clients. By way of background, in certain situations, a class action has benefits, including where there are a large number of claimants, each with relatively small amount of damages. Under these circumstances, it may not make sense from a cost standpoint for each of the claimants to bring an independent lawsuit. In this situation, pooling the claims together in a class action is certainly sensible. In contrast, where the individual damages are significant, such as here with the total loss of your home or business, we believe that the advantages of an independent lawsuit far outweigh those of a class action. The most important advantages of suing individually are control and leverage. When suing independently, you are in the driver's seat, especially when it comes time to decide whether to accept a settlement or to continue to trial. In contrast, in a class action, this decision is driven more collectively by the class. Also, importantly, the compensation and proceeds in an independent lawsuit are not limited by the interests of the other plaintiffs, and rather are tailored to your specific damages, which could mean a significantly higher payout when compared to a class action. Finally, with respect to timing, independent lawsuits often have a faster timeline and outcome for resolution when compared to class actions, which may tend to draw out over a period of many years. This extended timeline for a class action may be driven by class action lawyers who could be incentivized by increased attorney's fees over a longer period of time. On behalf of our clients, we have chosen the benefits of an independent lawsuit against DWP. Again, if you would like to join us or would like more information, please do not hesitate to reach out to us, and I would be happy to contact you directly. One of the next questions that I receive from many of our clients is, would any recovery in the lawsuit against DWP affect your insurance proceeds? Generally, proceeds from our lawsuit against DWP may not have any effect on your insurance claim and proceeds. Again, please contact me directly and I would be happy to discuss your particular circumstances with respect to your insurance policy and our lawsuit against LADWP. I next would like to address the insurance claims arising from the Palisades fire and answer some of the most common questions. So let's switch gears now to your insurance claim arising out of the Palisades fire. Again, my goal here is to answer some of the most frequently asked questions. Two of the main issues I've been advising and assisting my clients on with respect to their insurance claims are, number one, their insurance company's obligation of good faith and fair dealing when it comes to handling their insurance claim, and number two, in the difficult and very unfortunate situation where the limits of the insurance coverage are inadequate to fully pay for your loss, the question becomes, is there any potential responsibility on the part of the insurance agent or the broker who originally placed the inadequate insurance? So let me deal with each of those two issues separately. First, with respect to the insurance company's obligation of good faith and fair dealing, let me give a quick recap of the law on this issue. In California, the law is very well established that an insurance company owes a duty of good faith and fair dealing to their own insured. This duty applies to first-party insurance claims. In other words, when you, the policyholder, are making a claim to your own insurance company. This is exactly the case here in the context of the Palisades fire. Under California law, in the context of a first-party claim, the law is uniquely favorable to you, the policyholder. Your insurance company must act in good faith and deal with you fairly when handling and adjusting your insurance claim. So, what constitutes a breach of this duty? It may occur, for example, if your insurance company withholds policy benefits unreasonably or without proper cause. This type of conduct could allow a policyholder to recover damages including economic losses, emotional distress, attorney's fees, and in some cases punitive damages if the insurer acted with malice, fraud, or oppression. When it comes to punitive damages, one measure is an amount that is sufficient to punish the wrongdoing insurance company and to make an example of that bad conduct. That's why punitive damages are also referred to as, quote, exemplary damages. As you can imagine, with respect to a very large insurance company with revenues into the hundreds of billions of dollars each and every year, these type of damages, punitive damages, can be incredibly significant, and even a small risk of punitive damages can lead to a big settlement in favor of the insured. So what are some specific examples of bad faith? You may have a claim for bad faith if your insurance company deliberately undervalues your claim, wrongfully denies your claim, or engages in a pattern of behavior that is intended to limit their payment under your policy. Generally, bad faith requires some type of affirmative or deliberate conduct by your insurer that is designed to avoid paying the benefits that you are entitled to under your policy. Additional examples of bad faith include misrepresenting the policy language or the facts underlying your claim in order to deny or limit a claim, unjustifiably and unreasonably delaying investigation of your claim, unreasonably delaying payments on a valid claim, failing to provide proper written justification for a claim denial, failing to conduct a full investigation before denying a claim, engaging in conduct to persuade an insured to accept an unreasonably low payment, or unjustifiably sending burdensome and unnecessary document requests to the insured. Prior bad faith judgments have also included bullying tactics designed to induce an insured to accept a lowball payment under the policy. If you believe that your insurance company has not acted reasonably and fairly with respect to handling your claim, please contact me directly and I would be more than happy to discuss these issues directly with you in the context of your particular claim and the best next steps. In assisting my clients since the Palisades fire, one of the most difficult and unfortunate situations is where my clients' actual losses far exceed the limits of their insurance coverage, or when the insurance company claims an exclusion applies to the insurance coverage. First, you need to carefully review the terms of your policy, including the policy limits and exclusions. These policies are long and complicated documents, and I would be happy to help. Now, if the policy review confirms the limit or the exclusion which the insurance company is relying on, what to do next? One area to review is the potential liability of the agent or the broker that originally placed your inadequate insurance. By way of background, generally, California courts have held that an insurance agent or an insurance broker does not have an affirmative or active duty to advise or recommend specific or adequate insurance coverage. However, there are very important exceptions under the law which could create potential responsibility by the agent or the broker under specific circumstances. And when I refer to potential liability by the agent or broker, what I'm really talking about here is a claim under their professional liability insurance policy. So, what are the exceptions under the law which could create liability by the agent or broker? One of the exceptions that has particular application to the Palisades fire is where you, the insured, indicated to the agent or the broker at the time you placed the coverage that you specifically wanted replacement cost coverage for your home. The agent or broker acknowledged this request and agreed to procure this coverage, but failed to do so. California courts have held that an agent who verbally represented there would be 100% replacement cost coverage, regardless of policy limits, was liable for failing to deliver the agreed upon coverage. In addition, California courts have also held that an agent or broker may also be liable for misrepresenting the nature, scope, or extent of insurance coverage. If you feel that your agent or broker may be responsible for placing inadequate insurance, please contact me directly, and I would be happy to discuss your particular circumstances and potential next steps. Next, I would like to address the unbelievable number of advertisements and solicitations from attorneys offering to assist you with your losses as a result of the Palisades fire. The question is, do you need one? Personally, one of my biggest concerns with these ads and solicitations is that many of these lawyers do not highlight any type of experience in handling complex public entity litigation, such as against DWP, nor any experience with complex insurance coverage issues or insurance bad faith claims. Rather, many of these ads seem to be from the same lawyers that have ads on buses, billboards, and the television seeking clients that are injured in a fender bender, a dog bite, or a slip and fall. I am also concerned with the ads that offer to assist you with your first-party insurance claim in exchange for a percentage of your insurance proceeds. Remember, this percentage or contingency fee will be deducted directly from the payment by your insurance company, which could mean a very significant reduction to your net insurance proceeds. Let's say, for example, you have a $3 million homeowner's policy and your insurance company pays the full policy limits. A 10% off the top fee by the attorney would be $3,000 from your net proceeds. Now, let's say an attorney spent 10 hours assisting you in preparing and submitting your insurance claim. This represents a cool $30,000 an hour to the attorney. In short, I would be very cautious and wary of attorneys that charge a percentage of your first-party insurance proceeds. If you do hire a lawyer, you may wish to consider an hourly arrangement rather than a percentage fee. That way you can see the type of work and value that he or she, your attorney, provides to you. And you are in full control to continue that attorney-client relationship only as long as you are satisfied with the attorney's work for you. In contrast, if you do enter into a contingency or percentage arrangement with an attorney, keep in mind that it may be very difficult to terminate the services agreement without paying the full fee or a significant part of that fee to the attorney. On this issue, I would pay particular attention to the part of the legal services agreement on termination of the legal services and make sure that you fully understand and agree to those terms. If you are considering a contingency or percentage fee arrangement regarding your first-party insurance claim, I would be happy to review any proposed legal services agreement that you are considering entering into. In short, it is extremely important that you make an informed decision before hiring an attorney on a percentage fee basis when it comes to your first-party insurance claim. Once you hire him or her, it may be very difficult to reverse course. So, when may it be appropriate to retain an attorney to assist you with your Palisades fire insurance claim? The answer to this question really turns on how your claim process is going. If you feel that your insurance company is treating you fairly and is responding to you in a manner that is timely, honest, and accurate, then trust your instinct. To be clear, most insurance companies and their adjusters do the right thing and fairly adjust the claims under their policies. However, unfortunately, this is not the case all the time. As a result of the Palisades fire, there are well over 5,000 insurance claims being adjusted, most well into the millions of dollars each. The total losses from the fire are estimated to be well into the billions of dollars. With losses of this extent and this magnitude, we expect there will be many bad faith claims, and I am already advising a number of clients on this issue. In conclusion, I hope this information has been helpful, and again, please do not hesitate to reach out to me directly, and I would be happy to speak with you about your particular claim, or, as I noted, please contact me if you would like more information about joining our lawsuit against LADWP. Thank you.